Well, this presentation will cover Chapter 12, Open Fields and Abandoned Property. Now, the Fourth Amendment to the Constitution does provide for protection against unreasonable search and seizures of a person's house, of the person themselves, of their papers and their effects, but this doesn't include open fields. Law enforcement officers may search for items of evidence in the open field without a warrant or probable cause, and may seize items if they have probable cause to believe that the item is incriminating character, subject to seizure under the laws of the officer's jurisdiction, which means if you find contraband, because contraband is illegal, would be something like you see a marijuana plants growing, or an illegal still or something of the sort that is contraband, you can seize it because seeing it gives you the probable cause. Or if you have probable cause that something connects to a crime, you can then seize it in an open field. But exactly what is an open field? I mean, that can, if you just take it literally, it would be a field that's open. But it also includes things like forest and woodlands. In fact, an open field is all space that is not contained within the curtilage of the home, and it need not be a field, and it need not be open. Your cow pastures are considered open fields, even though they've got barbed wire fence around them, or a small set of woods, or the area of the beachfront. Different places like that would be open fields. Curtilage is the area around the house that harbors intimate activities associated with domestic life and the privacy of the home. So pretty much it's anything that's inside the fenced area of the house, inside the fenced backyard, the house itself, the garage, that you would normally consider part of your home, not part of your farmland, but part of your home. It would not include the pasture land behind the house, or the area that isn't cultivated. I mean, if you mow the grass there, with your push mower, that's probably going to be in the curtilage. Okay, the area within the curtilage is determined by considering 4 different factors. The proximity of the area claimed to be curtilage to the home, whether the area is included within an enclosure surrounding the home, or the nature of the use of the area is put, and then the steps taken by the residents to protect it from observation by people passing by. Then you have a privacy fence around your backyard. If your backyard is, could be a full acre, and it would still be in your curtilage. On the other hand, without a privacy fence that's open, it's less likely to be considered part of your curtilage, because anybody can view things there as they pass by. In determining the extent of the curtilage, the definitive trend among lower courts after the Supreme Court decision in the case of Dunn is to use the totality of the circumstance approach and determine the extent of the curtilage, with the distance from the individual dwelling as one of the many factors that's weighed in making that determination. So they look at the totality of the situation and how the place is utilized. If you're grazing cattle on it, it's probably not going to be within the curtilage, but if you got your swing set for your kids inside a privacy fence, it probably is. Now, if you have a multiple occupant dwelling, an apartment complex, duplex, something of that sort, generally the shared areas of these multiple occupancy buildings are not entitled to the Fourth Amendment protection, because the general public has access to them. Your common area of the apartment complex, anybody can access it to go to your neighbor's house. So you can't say you have privacy in the common area. However, with that said, in the case of Fixel versus Wainwright, 2 law enforcement officers had been informed that narcotics were being sold in the defendant's premises. They observed the defendant's residence in a 4-unit apartment complex. Over a 45-minute period of time, several people entered the apartment house and left, which is an indication that they're selling drugs. Each time the defendant went into his backyard and removed a shaving kit from beneath for some rubbish under a tree. One officer then went in the backyard, seized the shaving kit, while the other arrested the defendant. Chemical analysis received that this shaving kit contained heroin, and the courts held that the backyard was a protected area and that the seizure and search of the shaving kit was illegal. And now in this case, the backyard area was for the apartment not a common backyard. So it wasn't one that was enjoyed by the general public. You couldn't generally walk into that backyard because it was contained as part of that particular apartment. Garages and their area immediately surrounding is ordinarily considered part of the curtilage, especially if it's near or attached to the dwelling. You get a lot of detached garage, but they'll have a breezeway, a little overhead walkway that will attach to the house. In fact, in my neighborhood, it is a deed restriction that if you put a garage on, you have to have it attached. I've got a neighbor that has an attachment that goes straight from one wall to another. You can't walk under it to keep out of the rain because there's no doors in either place, but they are attached, and it falls within the deed restriction. That garage is definitely within their curtilage. In the case of State versus Ross, where the garage was located within 25 to 40 yards from a street abutting the defendant's home, the court prohibited the warrantless entry by the police into the area immediately surrounding the garage. So in that case, the garage and the area between the garage and the house all became part of the curtilage. Now, as far as other outbuildings and determining whether an outbuilding is part of the curtilage, courts consider factors such as the distance from the dwelling to the house, the presence and location of fence or other enclosures, how the building is used, and attempts to protect the area from observation. I've got a couple sheds in my backyard. They would be considered part of the curtilage because they're within the fenced yard, and they are somewhat protected. As far as sight from the road, not completely, but they are protected because of trees and brushes and such. Even though the fence is only a chain link fence, but they are somewhat protected from public view. Now the term open field may include any unoccupied and undeveloped area outside the curtilage. An open field need not be open nor a field, as in those terms used. For example, I've already mentioned wooded areas. You could have a large pond, or those all would be considered open areas. Plain view on an open field or observation into a constitutionally protected area. Okay, law enforcement officers may make a warrantless observation into a constitutionally protected area from the open field, the air, or public vantage point if the observation does not violate reasonable expectation of privacy on the part of the person whose premise or activities are being observed. So you have a right to privacy in your home, but if your home has a 6-foot tall glass window that is open to the main road, and you leave the windows wide open where anybody walking down that street can see in them and see your marijuana plants growing right inside, you cannot claim your expectation to privacy because anybody in the public can walk by and look at it. Case in point, we had a house that was actually a second floor window where they had a marijuana grow. The rocket scientist of a drug cultivator left the windows open on the house, and of course he had the grow lights up in there, so they would come on at night, which was very convenient in illuminating the open window where anybody walking down the street could look up and see them. And someone did, and they called the police, and narcotics went by, and they looked, and it's, oh gee, there's a marijuana glowing in there. There was no violation for the officers looking up into it, because even though it was within his private residence, it was readily viewable to anybody walking down the street. Now, as far as driveways in general, if an officer gathers information while situated in a public place or a place where the ordinary citizen with legitimate business might be expected to be, the officer does not invade someone's reasonable expectation of privacy. So your driveway in your front yard where the delivery man would pull up, the mailman would come up and pull in there to drop your packages off, or the UPS man, or where the Fuller Brush man would come by to knock on your door and go by, or just any door-to-door salesman would show up. That would be considered an area where the general public would have access, and you would not have a reasonable expectation of privacy in that area. Therefore, an observation by a police officer from an ordinary means of access to the dwelling, such as the driveway, walkway, front porch, or sidewalk, may not violate the person's reasonable expectation of privacy if a member of the public could have made a similar observation. Now, that is making an observation from the street, not using a listening device to listen past the walls, or infrared device to look into the walls, or even using a dog to sniff the odor coming out of the house, which is a recent decision in the courts that said that you could not do that. Now we're going to talk about abandoned property. Now, a law enforcement officer can seize any abandoned property with or without warrant, or with or without probable cause, because it's abandoned. So you no longer have a right to privacy if you abandon something. So if you put it out in your trash, or you discard it, you throw it down on the ground as you're walking by, that's abandoned property. Property that is abandoned when it is considered abandoned when its owner has voluntarily discarded or left it behind, or otherwise relinquished his or her interest in the property so it no longer retain a reasonable expectation of privacy with regard to it. So you return a rented car and you left something in it, that's abandoned. You put something in your garbage can and put the garbage can on the curb, that is considered abandoned property. If you voluntarily throw something down, if it's drugs, and the officers haven't done anything unlawful to make you throw it down, that's abandoned property. That will occur a lot. You stop someone on traffic and they'll throw drugs out the window. Often you're just going to stop them to write them a ticket, but when they throw it out the window, then they've abandoned it. When you abandon property, the courts are going to look at the totality of the circumstances to evaluate whether you intentionally abandoned it, or you intended to abandon it or not. The court rely on two principal factors in determining whether you intended to abandon the property. Disclaimers or denial of ownership of property, which we used to run up on kids that were rolling the dice, playing craps with their dice out in the yards, when they'd have a lot of money laying on the ground, and when the police come, everybody would walk off, and they would you'd walk up to them and ask them, whose is this? And undeniably everybody would say, oh, it's not mine, not mine. Well, that was abandoned property. We'd collect it and turn it in as abandoned property. We knew it belonged to one of the kids there, but which one is a good question, because they were gambling with it. The reason they didn't want to admit it, because gambling was illegal and they could be arrested. So denial of ownership is something. You'll have people that will deny the drugs are theirs when you spot them. If they do that, they've just added to the fact that they've abandoned it. And then physical relinquishment of the property, throwing it down, putting it in the garbage can, something of that sort would be a physically relinquishing it. Now, a person who established a reasonable expectation of privacy in property has not abandoned that property, and the property may not be searched or seized without a warrant or other legal justification. So, even if you put it in your garbage can, but if the garbage can is still behind the fence inside the curtilage in your house, that's not abandoned yet. It doesn't get abandoned until you bring it to the curb. You still have an expectation of privacy inside the curtilage. And as far as premises, whether you abandon your apartment, the house, the motel room, the following are examples of factors that the courts examine and the totality in order to determine whether you've abandoned those premises. Have you removed your personal belongings? You've got an apartment and it now has no furniture or very little furniture left in it. All the clothing's gone. That's usually abandoned. Especially if you leave it open, don't lock the doors. And you're being observed vacating the premises or telling someone you're vacating, particularly the landlord, I'm moving out. Or you tell your neighbors, I'm moving out of this town. I can't stand it here anymore. I'm leaving. And then they take their belongings and leave. Those would all be things that would indicate that the person has abandoned that property, and then the officers would have a right to search for what they left behind, because what they left behind is abandoned property, and they have no expectation of privacy once they abandon the property. Other things, failing to pay the rent for a long period of time. Being a couple of days behind wouldn't do it, but if you go 3 or 4 months, or your long absences, you just don't come back. Fail to communicate to anybody regarding the premise. The place is falling apart. You don't call people to check on it, clean it up, or anything. Failure to attend or to care for the premise, or holding a moving sale, turning in keys and paying the final rent and other bills. Having the lights disconnected. Having the phone disconnected if you actually have a physical phone left in the house. Having the gas shut off. Those are all things that say you're moving and that you are abandoning the property. Now, as far as garbage, absent any state law to the contrary, when you leave your garbage outside the curtilage of the home, you have no longer have an expectation of privacy, and you can expect, if you're a drug dealer, that some narcotics officer is going to come along and scope your garbage up before the garbage man gets there. But garbage, again, left inside the property still is not abandoned. So you have to wait till they put it on the curb. You can't go get it out of the trash can, the garbage can right next to their house. To have a valid abandonment, property must be abandoned voluntarily, not as a result of unlawful activity by the law enforcement. Property abandoning as a result of illegal police conduct will be excluded from evidence. The individual where you start chasing someone without probable cause or reasonable suspicion, people can run, but when the police are running after them, then if they throw something down, that's involuntary. Now, if someone's running and they see the police and run, the officer can follow them as long as the officer doesn't try to stop them until they do something suspicious or something that will help the officer develop probable cause, and they abandon something. Then the courts have ruled that is abandoned property, and you can use that in court against the individual. Now, finally, we're going to talk about a case of garbage in Felix Flores versus Texas. It's a 2010 case. An Hays County Narcotics Task Force officer who'd been a police officer for quite a while, and during the course of his career, he observed marijuana and illegal drugs on many occasions. Well, in February 2007, he received an anonymous tip that there was narcotics activity at an unspecified date at an address on Romana Circle, whichever, in Hays County. The anonymous informer also said he observed quantities of cocaine inside the residence in the past. So he gave him specifics, but he was anonymous, so we couldn't get a search warrant based on what he said because we don't know who he is. But his information may still be good. We're going to have to develop that information further. Okay, the informer gave him several details about Flores and the address that were later corroborated. Things like description of the house, what time the person comes and goes, all those kind of things help corroborate things. On March 1st, Fracas found residue. He collected the garbage, found residue that turned out to be marijuana in the garbage outside the home. And then again on March 5th, he searched the garbage again. This time he found some marijuana stem seeds and some more residue inside the garbage can. So that tells him that two different occasions, there's less chance that someone just passing by added their drugs to this particular person's trash can. That's why they'll often do several garbage runs and try to get things on more than one occasion. When the court looked at the totality of it, they said not only the anonymous informer's information, but also the items found in the garbage cans on those two dates, that added to the probable cause. The marijuana residue that was found on the 1st and the 5th originated in front of the address and were most likely not from a neighbor or passerby. The magistrate could reasonably draw that at least inference because of the doctrine of chance, that it was objectively unlikely that a person or persons unconnected to the residence would have placed marijuana in the trash can twice within a 5-day period. Well, I said it's important to do the two different ones because somebody could throw your trash in your trash can. They're not going to do it too often, but they could do it on one occasion. So if you've got two different occasions, that adds to the probable cause. And finally, given that the magistrate could reasonably infer that the anonymous informer had familiarity with Flores and the affairs because of corroborated information, the magistrate could reasonably conclude that the informer's tip regarding the illegal drugs at the residence, although perhaps insufficient in itself to establish probable cause, was nevertheless a circumstance to be considered along with all the other circumstances in determining that probable cause existed. So you got the garbage, you got the anonymous tip, you add those together, and in view of the foregoing, the court held that the magistrate had a substantial basis for concluding that probable cause existed, that there was at least a fair probability or substantial chance that marijuana would be found at that residence. So the warrant was based on probable cause and was a valid warrant based on a garbage run with additional information to go along with it.
Well, that concludes this presentation. Next up, we're going to be looking at interrogations, admissions, and confessions as found in Chapter 13 of the book.